first case to come before the court is John and Mary Chlebina v. Stephen R. Swain et al. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so stay behind the podium. Please introduce yourself, keep your voices up. You should not use the names of children or minors or victims should they be relevant to what you have to say. You can refer to those folks by initials or terms like the child. The judges have read your briefs and we're ready to proceed when you are, and I would just ask appellant's counsel, would you like to reserve time?
Yes, please, I'd like to reserve the full 5 minutes.
Very well, then you may start when you are ready.
Good morning. May it please the court. My name is Marshall Pitchford, and I have the privilege of representing the appellants in this case, Landmark 2, Landmark 4, and Steve Swain. This morning, we urge a reversal of the trial court's decision ordering the release of company founder and former President Jeffrey Gordon Creed's written answers to 5 separate questions compelled by the trial court. We urge reversal for 2 separate reasons. First, his answers involve facts and circumstances from 2017 and thereafter, while the issues in this case surround simply the plain language of a settlement contract that was entered 16 years earlier in December of 2001. The second reason we urge reversal today is because the answers contained in Mr. Gordon Creed's sworn statement reveal a portion of the trade secrets that were developed by Landmark and my clients during 2017 and thereafter, and they are protected under the Ohio Uniform Trademark Secret Act. At the heart of this case is a settlement agreement that occurred or that was entered in 2001. However, the story starts before that. Almost 30 years ago, several different organizations and groups and individuals brought suit against my client, including one of those folks was appellee John and Mary Chlebina, to determine whether or not my clients had the right to develop and produce oil and gas on the former Firestone estate in Bath Township. The estate takes up approximately 1,500 acres at the time and was conveyed from the Firestone family to the Ohio State University with a reservation of rights for the oil and gas. 2 separate, at least I should say, 2 separate lawsuits resulted from that. The first was resolved here at this court in 2000, where this court found that Landmark did have a right to produce oil and gas from the premises, and that the deed from Mr. Firestone to Ohio State had effectively reserved all those rights. The second lawsuit brings us essentially here today because it ultimately ended in the 2001 settlement that's before the court. That 2001 agreement essentially defined what Landmark was able to do on Mr. Chlebina's property. It determined what a well was, it determined how many wells could be developed, and it determined how they could be developed, and it also created a cost-shifting mechanism, easy for me to say, to the Chlebinas in the event of a directional drill was required. One of the things that were set forth in that agreement was the order of the wells were to be drilled. One well was called the 7F, the F stands for Firestone. One well was called the 6F. The 7F in this instance was drilled first, and the 2nd F was drilled second. What the lawsuit we are here for today involves Landmark's plans to what's called recomplete well 6F, the second well. The contract, and we'll get to the language in a moment. The language of the contract. Before we get to the language of the contract, it's important to understand the life cycle of a well. There are several stages. First, a well is drilled. Second, a well is completed. Then it is produced. Sometimes it is recompleted. And then, of course, a well is plugged, right? So that's the end of the life cycle of a well. So it's drilled. A drill is simply taking, just as it sounds. You take a drill bit and you drill straight into the ground, a mile, half mile, however distance, through different formations in the earth, which are called formations, or we call them layers, right, if you were in the 8th grade science class. The completion is the installation of tubing and casing down the hole once it's been drilled. So if you do nothing else, all you'll have is a hole straight through the ground and into the rock. What happens next is the completion, which you stick in the tube, and then you stick inside the tube or inside the casing, you get the rest of the mechanism that helps bring up the oil and gas. Of course, production is when you bring up the oil and gas, and when you recomplete a well, that is a process where you essentially decide to produce that well at a different formation. So you can either, you can produce at a Tripolo level, you can produce at a Clinton level, or you can produce at different levels. But what happens is, once you've depleted a reserve at a certain level, then you want to go to a different one. That's what's happening here. The 6F was completed to the Clinton level, and now my client intends to go to a deeper level, which is under the contract is permitted. What's at issue is whether or not he is permitted to go on a directional basis, which means go down that same hole, and then about halfway down, I believe it's 1,600, 1,800 feet down, turn on a diagonal and go deeper this way. So that's what's at issue in this case.
I was going to say, and is the main issue in this case, the cost is going to be really. The cost that it's going to be, because if you do directional, it's going to be divided cost.
So as a part of our counterclaim for the declaratory judgment, we have asked for the court to determine if that's what the contract says. So I don't think there's any dispute that if there is a directional drill that's allowed, yes, in fact, the cost will be upon the appellees, in this case, the Chlebina's, to cover the difference. Right? And the idea was, when the contract was entered, was that if there is ever a time such as this where we have to go on a directional basis, for whatever reason, if you're off the property or here, because if we were to drill straight, we are required to share royalties that are beyond the parameters of the Chlebina property. But if we go on a directional basis, the ODNR, the Ohio Department of Natural Resources, determines the circumference of the well based on the bottom of the hole, not necessarily the top of the hole. So by our client going on a directional basis, it still is able to reap the full benefit of its rights. Does that make sense?
Yes, and so as I understand it, then the 5 questions that were answered were submitted to the trial court, and the trial court reviewed them and felt that they were discoverable.
That is correct.
Okay, now, I guess the first question I want to ask you, do we have the 5 questions and the answers in the record?
I have checked with the clerk's office. Those, I've been told that yes, that information has been provided to the court. There were 2 separate packets that were provided to the trial court in camera. One was that docket entry, I believe, was 138, and the other is 172. But I will double check that while the appellees are talking. They are both notices that were filed with the court, indicating that we submitted them in camera. I actually spoke to the appellate clerk of court yesterday and was told that the court did have those packets. There's about 75, 76 different pages that include 7 different invoices, 5 different NDAs, the test results from numerous test interpretation of those tests, the seismic results, and then there are also the 5 answers to the 5 questions for Mr. Gordon Creed. And I would note for the court in particular, there are 3 answers, 3 paragraphs in particular that are particularly sensitive for Landmark. They are the answers to question A subpart 6 and A subpart 7, and then answer C. So as the court is, we are arguing that the entire set of answers are irrelevant given the fact that the plain language of the contract says whether or not the 7F was drilled successfully to the Trempealeau Formation. It's undisputed that
Can I
a drill
stop
bit.
you- Can I stop you with that? Because when I was reading everything, and, I mean, your primary argument is the trade secrets. I mean, you know, material. But I know you did intersperse throughout that these were not relevant. But I'm just a little concerned, because can we even look at the relevance, I should say, I can't talk today, the relevance of these documents and these answers, because this is an interlocutory appeal. Then the only reason you get to raise it is based on, you know, privileged or trade secrets, those type of things that there's provision for. You can't just say it was not relevant and raise the issue on appeal.
I understand the question. It's a good question. Yes,
I'm glad you understand the
yes,
question.
there is case law. Yeah, we will see there is case law that allows the court to, if you will, step aside from the relevancy question and address only the matter that's on interlocutory appeal being the trade secret. We would urge the court to, in its discretion, which I believe the court has because the issues are on appeal and it is a part of the order, to go ahead and reach that question. It is at the heart of this case that whether or not things that occurred, and there are a host of things that have occurred, you know, from 2017 after.
And counsel, I do want to just let you know you're moving into your rebuttal time. I don't want to interrupt.
Well, I will go ahead and reserve the rest of my time unless there are further questions with respect to either the relevance or the trade secrets. Thank you.
Good morning, Your Honors. Christine Garitano in the law firm of Harps Becker on behalf of plaintiffs appellees John and Mary Kay Chlebina. We urge the Court of Appeals to affirm the trial court's discovery order, ordering and compelling answers to questions that were not responded to during deposition. I'll note again, we're here on a discovery order. While that order did involve a determination of trade secrets, we believe that the case law is clear that that order must be reviewed under an abuse of discretion standard. There's no dispute here that the trial court applied the correct legal standard to analyzing the trade secrets issue. I believe, and although Mr. Pitchford didn't get into it in his argument, their primary argument is a dispute over the factual analysis as applied to the legal standard.
But there's no case law that says abuse of discretion is here in Ohio, is that right?
Yes, there is. I believe that we cited a case from 2021 out of the 8th District Court of Appeals analyzing a discovery order for a trade secrets issue. That's Hans versus Cleveland Clinic. You'll find that at page 13 and 14 of Appellee's brief. That specifically states that it is applying an abuse of discretion standard based on the Ohio Supreme Court's determination that whether or not information is considered trade secrets is a question of fact.
It says question of fact, but they didn't analyze it under abuse of discretion, or they did?
They, in fact, did analyze it for an abuse of discretion.
And counsel, we've looked at the issue of trade secret and just privileged documents, obviously, many times on appeal. What does our case law say? Because you cited the 8th District Court of Appeals.
Correct. I don't believe that this particular district has spoken specifically on the issue of trade secrets under discovery standard. However, all of the cases of privilege that appellants cite relate to statutory privileges that are, doctor-patient privilege, attorney-client privilege. Those are different than a trade secret standard. And again, we're here talking about a discovery order. We're not talking about the merits of the case. I think that is quite critical both to the trade secrets analysis and to the relevancy issue to the extent that the court thinks it's appropriate to consider that. We're not talking about the ultimate issues. We're not talking about admissibility. As we know, admissibility and relevance are different standards. Relevance is much broader. The trial court here specifically analyzed the issue of relevance in its initial order on the motion to compel. It then went on to ask for additional information in order to analyze the trade secret question. It received that information in camera, so I'm a little bit hamstrung. I can't argue those facts to you here. However, it's clear that the trial court received that information to make that determination, did so, and issued an order articulating the basis for that.
So if it does say that there's gas and oil research involved, is there case law here that supports that research and that type of discovery is a trade secret?
I don't believe so, and the appellants haven't cited any Ohio cases to that effect, and the cases outside of the jurisdiction that it cited aren't relative to a discovery issue that we have here. In any event, any analysis of trade secrets is highly specific. So I don't think that anything would have a bearing on those issues, but the trial court asked for specific information that it could analyze, and it in fact did analyze it. The appellant's dispute then is simply with, how the decision came out, not whether she abused her discretion in ordering that.
I'm trying to figure out why it would be abuse of discretion. Because as a trial judge, if I'm looking at it, I would be looking at, because it is a very individual thing, and you're gonna have to look in camera at the documents and whatever evidence they have to determine that it's a trade secret. So how could you ever have discretion to say it is or it isn't?
Because a trial court is making so I think that it's an abuse of discretion for two reasons. One, because it's a discovery issue, and two, because it's a factual analysis. And the factual analysis is within the discretion of the trial court here. It's not as though the argument is that the trial court applied the incorrect law, in which case this court could apply a higher level of review. Trial court has the discretion to consider the facts before it and issue a discovery order, and that's what it did. And unless the court has any other questions for me, I'm just going to make one more point and then I'll sit down, which is that nothing in the law says that what information that is in fact considered trade secrets is absolutely excluded from discovery. In fact, the standard is that when discovery material is considered trade secrets, that it is still discoverable under an appropriate protective order. So even to the extent that this court finds that the trial court erred in determining that the information was not a trade secret, then the mandate from the trial court should be to fashion an appropriate protective order to protect that information, not to simply exclude it from discovery entirely.
I'm not sure if this issue is presentable on appeal in regard to relevance because of the interlocutory nature of it. However, I'm just wondering, trying to figure out why something 17 years later is relevant to the underlying settlement agreement that basically we're supposed to look at on its face.
The trial court's job in contract interpretation is to ascertain the intent of the parties. The Ohio Supreme Court has stated numerous times that the intent of the parties can be determined through extrinsic evidence to the extent that the language is unclear, ambiguous, or there are special circumstances or special meaning that should be applied to a particular contract provision. We contend all of those things are applicable here. Obviously, we have a dispute as to what the term drilled successfully means under the settlement agreement. We believe it is at minimally ambiguous. But we also think that there's special meaning because of the nature of the business and the agreement that was made in this case that makes extrinsic evidence applicable here. Types of extrinsic evidence that the Ohio Supreme Court has said is relevant to the inquiry of intent is the conduct of the parties. Our contention is, for some 20 years, the defendants conducted themselves as though their drilling was unsuccessful. Then they changed their minds. What was it that caused them to change their minds? I think that we're entitled to know that given the importance of the property rights, and as Your Honor correctly pointed out, the extreme cost associated with the drilling that the defendants are seeking to put upon plaintiffs in this case if they are successful. So all of that information is relevant both to ascertain the intent of the parties and to determine whether their plan, their cost is even effective given that they're trying to push those costs onto the appellants in this case. If there's no further questions, again, I ask that this court affirm the trial court's discovery order compelling the answers to the questions of Mr. Gordon-Reed. Thank you.
Further questions?
No, I'm sorry.
Thank you. Counsel, you will have 4 minutes and 2 seconds.
Okay. I'll talk faster than I did last time. A couple of points, if I may. First, as to the standard of review, in particular, the other side has held up the case in re alternative energy versus Ohio Edison. I would point out to the court that the discovery issue in that case was not under a Civil Rule 26 analysis. It was under an Ohio Administrative Code analysis that applies actually the old standard of whether or not something is reasonably calculated to lead to discovery of admissible evidence. That standard was done away with in 2020, and that particular case is, I would argue, constrained to its facts with respect to whether or not a trademark is a trade question of fact. I would also point out, contrary to counsel's contention, that nowhere in that decision is there any discussion of a standard of review as to whether or not the issues in that case were trademarks. Next, Judge Carr, to answer your question specifically when those materials were filed with the trial court, I was able to find those. They are at item number 90, and they are also at, which is on December 12th of 22, then also item 138, which was filed on May 16th, 2023. That would include the answers for Mr. Gordon-Reed at that particular submission. Again, we filed a notice with the court, submitted the materials in camera. Briefly, I wanted to discuss the fact that the trial court did not find any language, or the language at issue here, to be vague, ambiguous, unclear, nor did it make any finding with respect to whether or not there were any special circumstances. But, barring that, the court is that we are constrained to look beyond, constrained not to look beyond the plain language of the contract, which is drilled successfully. In deposition testimony, which is cited in the briefs, Mr. Chlebina conceded this point that, in fact, yes, there is no dispute that 6-7F was drilled to that level, and drilled means drilled, and produced just means something different. Lastly, I would argue and point out to the court that the conduct of my client in deciding to recomplete the 6F 16 years later is not inconsistent with its interpretation of the language of the contract. The question is whether or not the 7F was drilled, quote, successfully to the Trempealeau Formation. And then there's a sentence that says, if not, then we must do X. We must drill it straight. However, the contract does not say if it is drilled successfully what we have to do. The contract is silent on that point. So my client's conduct in first drilling the 6F straight is consistent with the agreement, and now its decision to drill the well directionally is also consistent with the language in the contract, because there is no
Isn't it
language.
contested that your client took the position that it wasn't successful, and then all of a sudden it is successful? And how is the appellee to know if they don't have access to information?
We have never taken, my client, one, has not been deposed. All we have here is the language of the contract. And what you see before you is just a plain reading of the contract. allows for our client to drill the well directionally. If it is drilled successfully, there is no language with respect to how it has to drill the 6F. Did I answer your question?
Yes.
I'm not sure I got the, I couldn't hear the entire.
It's okay, it's okay.
Okay.
You're gonna need to wrap up shortly, so I won't take any more.
My last point would be that on both the relevance question and whether or not the standard of review is consistent with, decades long of precedent being a de novo review or an abuse of discretion, the trial court did previously.
You are gonna have to wrap up.
Oh, sorry. That's my last, I'm sorry. On 2 occasions, found there were trade secrets, and then she reversed her decision in allowing this information to be produced, which we argue is arbitrary. Thank you for your time today. We appreciate your consideration.
Thank you. Thank you both for your presentation. The court will take the matter under advisement, and we will issue a decision in due course. On the day that it is released, the clerk of courts will mail a copy of it to both of you, and the opinions will also be posted on the Ohio